So that brings me to the idea of the necessity to make sure that in the continent we all accept in our national judicial frameworks the principle of universal jurisdiction.
The question of engagement, I agree with you, Madam Prime Minister. One of the problems of the Malabo Protocol and all other AU treaties is a question of translating those treaty obligations within the national domestic jurisdictions. And this issue of incorporating the principle of universal jurisdiction is part of that problem. How many of the 34 countries in Africa that are parties to the Rome Statute have domesticated the Rome Statute? How many have adopted domestic legislation? Very few. Treaties are signed, but nothing is domesticated. So the engagement, you're quite right to say, the engagement has to start within conversations at the national level, at the regional level, and so on.
What kind of challenges do you think Africa is facing in addressing, international crimes under localized jurisdictions?
Well, I think there are three challenges. First of all, let me say this. I think we need to remind ourselves that the International Criminal Court is just the principal mechanism in the machinery of international criminal justice. Or it ought to be that way. The International Criminal Court is not a court of first instance. So the real work that needs to be done at the national level. Because it is national judicial mechanisms, national courts, national tribunals, that ought to be the first port of call. States have a primary responsibility to try to investigate and try violations of this nature, right? So we need to strengthen the national judicial mechanisms, that's number one. But to do that, we need to ensure that national authorities, governments, political elites, and the whole machinery of the state understands what is at stake when we talk about international crimes. What has happened over the years is that you have had a number of states making commitments at the treaty level. So they sign up to the Rome Statute, they sign up to other instruments, for example, in the context of Africa, this Malabo Protocol, which is not yet in force. But then they don't do what they need to do at the national level to ensure that their own national legislation is then consistent with these treaty obligations that they have taken on by signing up to the Rome Statute and other instruments. They don't domesticate these international treaty obligations. They don't adopt implementing legislation, etc., etc. Now, unless they do that, then the mechanism for dealing with these things at the national level is obviously going to be problematic. So they need to do that. And then thirdly, there needs to be a serious commitment by national authorities to investigate and prosecute any suspects where they are found. Because if states don't do that, then you can't really rely on the international system, on the International Criminal Court, to deal with all these situations. The ICC should be a court of last resort because of the principle of complementarity. The ICC should only come in where the national authorities are either unwilling or unable to prosecute, or the machinery simply doesn't exist. So I think the future of international criminal justice is not just so much with the International Criminal Court. People keep focusing on the ICC. We should focus on the national judicial mechanisms. Do we have the machinery? Do we have the legislative framework? Do we have the willingness, the political will, and so on, to actually do something about the fight against impunity in the national domestic systems? If we do that, then I see the possibility of the world actually moving forward in the fight against impunity. If we don't, then we can talk all we want about the ICC and so on, but the ICC is not simply going to be able to deal with every situation that states ought to be looking at.
There's a lot of talk about African concerns. Do you think these talks are warranted?
Well, I do agree that there's been a lot of talk about issues of selectivity in choice of cases, situations for investigation and prosecution and so on. There's been a perception about Africa being targeted, etc. So those concerns are there. Are they warranted? Well, I do not think that you can say in a general way that they are warranted, because the accusation, for example, that the ICC is targeting Africa, that the ICC is pursuing a neo-colonial agenda to harm Africa, to humiliate African leaders, I don't think that is warranted. I think there's a misunderstanding about that. But there are genuine concerns about where the ICC ought to be going with its investigations in similar situations outside Africa and so on. And to that extent, I think we need to look carefully at these concerns. We need to address them so that we remove these perceptions of bias, of unfair, focus on Africa, etc., etc. And until that is done, we are going to have this, ongoing concern expressed by African countries, sometimes by countries that really just want to have an excuse not to cooperate with the ICC. So we need to remove that. We need to deal with that.
Is Africa flexing its muscles harmful to improving the performance of the International Criminal Court in delivering justice?
Yes, it is harmful. The countries that have been raising these concerns from the African region happen to be countries that form the largest bloc in terms of geographical regions of the membership of the ICC. So, as you know, out of 124 members, 34 are from the African region. And I think we need to take seriously any expressions of mistrust, any expressions of concerns about lack of fairness and so on coming from the African region, because by sheer number, they form the largest group of the members. So that has a potential to harm the image of the court, that has the potential to erode from the focus that the International Criminal Court, as the principal organ established for pursuing issues of international criminal justice and so on, ought to be focusing on. The concerns might distract both the ICC and member states from that central focus and the central objective, which is the fight against impunity.
Do you think more pressure is required on countries like Russia, China, and the United States of America to at least show some sort of, fairness in application of justice?
I'm not sure that the right word, or rather the right term, is pressure. I don't know how we can put pressure on Russia, on the US, on China, to get them to become members of the ICC. Membership of the ICC is a sovereign decision. Countries that have signed up to the Rome Statute and would like to be members have to go ahead and ratify it, etc. But what we can do is to keep up the conversation with these countries, to impress upon these countries that they have a responsibility as the big powers in the global order to take a lead, or to join those countries that are taking a lead in dealing with issues of impunity, in dealing with issues of international criminal justice, etc. After all, these countries were part of the group of countries that negotiated the Rome Statute. They were there until the end. In fact, the United States was quite active. It had positions that it pushed through. Compromises were made towards the very end of the process of negotiating the Rome Statute, precisely to accommodate the concerns, or some of the concerns, that the United States and other big powers had expressed. So it is unfortunate that having then managed to adopt the Rome Statute, we find ourselves in a situation where some of the central players, the big powers, have decided not to come on board and become members of the court. So we may not be able to put pressure on them because of the way that power politics works, but I think we can use our powers of persuasion again to try and impress upon these countries that it would be in the collective interests of the world if they were part of this process, and they can only be part of the process by ratifying the Rome Statute and becoming members of the court and participating in the administration of international criminal justice and in the fight against impunity, because that fight is as much in their national interests as it is in the national interests of every other country, big and small.
Will there reach a point where international criminal justice will be delivered on an equal or level playing field?
Yes, I believe so. I think all these disagreements, all these concerns that have been expressed by African countries vis-a-vis the ICC, vis-a-vis the United Nations Security Council, all these are issues that can be resolved by honest, meaningful, reasonable, constructive engagement. We need a dialogue involving not just African countries on their own, but a dialogue between African countries and the ICC and the Security Council and other stakeholders. A dialogue that hopefully would clarify that what is being pursued is, as I said earlier on, in the collective interests of the international community. Now, can there be a level playing field? I think we need to bear in mind that the prosecutions that are pending before the ICC, the indictments that have been made in situations in Africa have arisen partly because it is in Africa that the conflicts in which these violations of serious crimes of international law occurred. It is not as if the ICC just woke up and said, well, we are going to start with Africa. There are reasons for that. The majority of those cases were self-referrals by these African countries to the ICC. Now, there can be a level playing field if the ICC, either at its own behest, and here by ICC I'm talking about the Office of the Prosecutor, or the United Nations Security Council, at the request of the prosecutor of member states, would ensure that similar situations that deserve attention, that deserve investigation, are also looked at. And that would ensure that the focus is not just on Africa, but on other areas and other situations where potentially one might say there is a probable case of violations. And that would then remove the perception that there is no level playing field. So I think a level playing field is achievable, but that can only come about with constructive engagement between the various parties, the African states on the one side, and the ICC, the UN, and other stakeholders on the other side.